It is my great pleasure to introduce to you Professor Claus Kress. In doing so, it's a kind of a hurdle run. In doing so, I will follow the well-established ritual of acknowledging that he does indeed not require any introduction, while providing at least a short one. Professor Kress is Professor of International Law and Criminal Law at the University of Cologne, where he holds the chair for German and international criminal law. He's also the director of the Institute of International Peace and Security Law at the University of Cologne. Professor Kress is a distinguished scholar, and he is an experienced negotiator. He was part of the German delegation at the Rome Conference. He represented Germany in the Preparatory Commission, negotiated the rules of procedure and evidence of the ICC. He was head of the drafting committee for the regulations of the court, and he served as focal point during the negotiations of the crime of aggression in the special working group. In 2021, he was appointed special advisor to the prosecutor of the International Criminal Court on the crime of aggression. Professor Kress will deliver his keynote address on the new momentum regarding the prosecution of the crime of aggression. Professor Kress, you have the floor.
Thank you very much, Astrid. Excellencies, ladies and gentlemen, dear colleagues and friends. Thank you to Vienna University, and in particular to Dr. Astrid Reisinger-Corazzini for bringing us all together. This Vienna Conference could not take place at a better moment in time. The 25th anniversary of the adoption of the ICC statute coincides with an important new momentum regarding the prosecution of the crime of aggression. And this momentum has sharply called into question the distinct jurisdictional restraints that currently set apart the crime of aggression from the other crimes under international law in the ICC statute. The ICC statute's 25th anniversary is thus the perfect moment in time to bring together politicians, diplomats, and legal experts to help preparing the ground for one comprehensive jurisdictional regime for all crimes under international law in the ICC statute. Vienna is a most suitable venue to gather for that purpose. The two previous speakers have already given quite a few reasons for this. Let me add two names to the picture, because it were Austrian facilitators, Nadia Kalb and Konrad Bühler, who is present here with us, together with our convener, Astrid Reisinger-Corazzini, who masterfully guided the last round of negotiations before the activation of the ICC's jurisdiction over the crime of aggression. Certainly, this year's 5th anniversary, this activation is worthy of recognition. It constituted a historic step in the evolution of international criminal justice, in that it marked the culmination of an almost century-old process of international debate. The fundamental idea behind this process is simple, clear, and powerful. Those state leaders who contemplate inflicting the horrors of a war of aggression upon the world should know that the world considers such conduct so profoundly reprehensible that punishment to be imposed by a permanent world court of criminal justice would follow. Generations of dedicated politicians, diplomats, scholars, and members of civil society have contributed to the realization of this idea. Among them, as was mentioned by Astrid, the unforgettable Ben Ferenc, who has so sadly left us earlier this year, he stood out by his particularly shining role. But if Ben would be with us today, he would be crystal clear that the 5th anniversary of the activation of the ICC's jurisdiction over the crime of aggression cannot be just a day of celebration. Instead, Ben would urge us to honestly recognize that the historic step forward was made at a painful price, that of accepting unprincipled and debilitating jurisdictional restrictions. How this came about, we shall be recalled in greater detail later. But let us remember already now that at the Rome Conference, the crime of aggression only barely made it within the jurisdiction of the court. In that respect, decisive credit is due to the non-aligned movement. In May 1998, the non-aligned states met in Cartagena de Indias and adopted a declaration on the forthcoming Rome Conference. In this declaration, the non-aligned movement stated that the ICC statute should include, I cite, the heinous crimes of international concern, and in this regard, strongly support the inclusion of the crime of aggression. End of quote. During the Rome Conference, the non-aligned states accordingly insisted on the inclusion of the crime of aggression in the jurisdiction of the ICC, and supported by a few other states, such as Germany and Italy, they ultimately prevailed. The fact that the crime of aggression has been part of the court's jurisdiction from the outset is very important. Yet, this inclusion happened in the form of a placeholder, which essentially amounted to a mandate for states to define the crime and to set out the conditions for the court's exercise of jurisdiction. The struggle over the jurisdictional limb of this mandate would haunt the litigations for almost 20 years to come. The 5 permanent members of the UN Security Council in particular were adamant to confine the court's scope of action as much as possible to a Security Council-based exercise of jurisdiction. In the summer of 2010, at the first review conference on the ICC statute in Kampala, the P5 and some followers prevailed to a significant extent. Most importantly, the Kampala Agreement entailed that in the absence of a Security Council referral, crimes of aggression arising out of an aggression committed by or against a non-state party would categorically remain beyond the court's reach. Despite this heavy restriction, it was decided in Kampala to defer the activation of the court's jurisdiction over the crime of aggression for at least 7 more years. The activation decision was taken by the Assembly of States Parties in the night of 14 to 15 December 2017 in New York. But even this activation decision proved to be far more than a mere ceremonial act. Instead, France and Great Britain in particular had been playing hardball one last time. They demanded to get their restrictive interpretation on one remaining point of controversy explicitly confirmed in the activation resolution. The great majority of state parties was of a different view. But in order not to let the activation to be deferred to an uncertain moment in the future, the majority ultimately chose not to oppose to the inclusion of language as requested by France and Great Britain in the activation resolution. Yet, France was still not content and asked for a certain paragraph to be moved from the operative part of the resolution to its preamble. For Switzerland, at this point, enough was enough. And so this state disagreed. Hereby, the drama of the negotiations had peaked, and an almost incredible possibility loomed large in the nightly conference room at UN headquarters. The possibility that the century-long journey towards providing for a permanent international criminal jurisdiction over the crime of aggression would ultimately derail because of the question as to whether a few words should be placed either in a preambular or an operative paragraph. At this absolutely critical juncture, delegates from South Africa, Samoa, and Portugal, each of them in their own way, made valuable contributions to prevent the negotiations from collapsing. This enabled Vice President Sergio Ugalde from Costa Rica, after finding that the French proposal had met with opposition, to ask one final time whether there was consensus in the room. This was followed by a dramatic moment of suspense, during which probably not only my knees went weak. Then it was clear that France had decided not to play hardball beyond the extreme. Thus, the activation resolution was eventually adopted by consensus. I have set out this last step of the struggle in a little more detail to give you a better sense of why the activation of the court's jurisdiction over the crime of aggression left many states with mixed feelings. Yes, certainly, there was the feeling of having made a historic step. The crime of aggression had been defined, and a robust consensus about this definition had been secured. That extended to non-state parties, including, notably, the Russian Federation. Also, the misguided idea that the Security Council owned a monopoly over criminal proceedings for the crime of aggression had been rejected. But at the same time, there was an uneasy question. Was it all worth the tremendous effort? Could the activation of the Kampala amendments ever make any meaningful practical impact in view of the court's heavy jurisdictional restraints? And there was a strong sense of disappointment about the way a few states had imposed their will to a very considerable extent. This disappointment may well explain why many African, Asian, and Latin American states have yet to develop a full sense of their co-ownership with respect to the Kampala amendments. This possibility was gently alluded to by South Africa's Kampala delegate, André Stemmet, who stated as follows, I quote, "The major weakness is, of course, that non-state parties will be able to commit aggression with a sense of impunity. And this reflection of realpolitik may result in a very slow process of ratification and acceptance." End of quote. In the years since 2018, European states parties have contributed their important share to the fact that Kampala amendments have remained to date a mere law on the books. Here are 4 examples for Europe's conspicuous silence. First, In 2019, Turkey conducted its massive military operation Peace Spring in Syria. Although there was a very serious possibility that this use of force fulfilled the state conduct element of the crime of aggression, this crime was not a salient issue in the discourse among governments of NATO member states. Second, in 2021, that is 3 years after the activation of the ICC's jurisdiction over the crime of aggression, the European Union chose to simply ignore that crime on the day of International Criminal Justice. High Representative Borrell stated as follows, I quote, "Every 17th of July, we commemorate the historic adoption of the Rome Statute of the International Criminal Court in 1998. As an important moment to reflect on the importance of fighting impunity and bringing justice to the victims of the most serious crimes: genocide, war crimes, and crimes against humanity." And then, full stop. Third, in May 2022, the European Union adopted an amendment of its regulations on Eurojust. This amendment extended Eurojust's scope of action with respect to genocide, crimes against humanity, and war crimes. The crime of aggression, however, was left out. Left out still at this moment in time. And fourth, even European governments, apart from Ukraine, kept silent about the crime of aggression throughout the lead up to 24 February 2022, as well as for months thereafter. It is puzzling to see such a sidelining of the crime of aggression even years after the activation of the court's jurisdiction over the crime of aggression. For, as is well known, the crime of aggression was at the very heart both of the prologue to international criminal justice after the Great War and of the breakthroughs of Nuremberg and Tokyo. I quote, "Somebody has been responsible for this war that has taken the lives of millions of the best young men in Europe. Is not one to be made responsible for that? All I can say is that if that is the case, there is one justice for the poor and wretched criminal and another for kings and emperors." End of quote. This is how Britain's Prime Minister David Lloyd George in November 1918 set the scene for the first concerted diplomatic attempt to institute international criminal proceedings for aggression. Georges Clemenceau, the Prime Minister of France, emphatically concurred, and to that effect, his academic advisors, Ferdinand Larnaud et Albert de la Pradelle, made the following point. I quote again. "Alors que l'infraction à la paix publique d'un État entraîne les peines les plus graves, on ne comprendrait pas qu'une atteinte à la paix du monde demeura sans sanction." End of quote. Interestingly, Hersch Lauterpacht, Britain's emerging star at the sky of international law scholarship, made essentially the same point later, under the impression of Nazi Germany's wars of aggression. He said, I quote, "The law of any international society worthy of the name must reject with reprobation the view that between nations there can be no aggression calling for punishment." End of quote. Aaron Treinin, the academic advisor of the Soviet Union, had been arguing along the same lines, and he coined the term crimes against peace, under which the crime of aggression entered the international legal scene in Nuremberg. In his memorable opening speech at Nuremberg, US Chief Prosecutor Robert Jackson pulled all those threads together. He powerfully foreshadowed what culminated in Nuremberg's famous judicial pronouncement. To initiate a war of aggression is not only an international crime, it is the supreme international crime. There can thus be no doubt that in one way or the other, France, Great Britain, the Soviet Union, and the United States were the driving forces behind the crystallization of aggression as a crime under international law. How can it then be that decades later, France, Great Britain, the Russian Federation, and the United States worked so hard to minimize the prospects that this very crime could ever be adjudicated by the first permanent international criminal court in legal history? One important reason is that the judgments of Nuremberg and Tokyo had not come up with a clear definition of the crime, and that the prohibition of the use of force, as enshrined in the UN Charter, soon turned out to be surrounded by a gray area of genuine legal uncertainty, one which is reflective of deep-seated policy differences among states. It must be honestly recognized that this made it a real challenge to generalize the precedents of Nuremberg and Tokyo. In that context, let me recall that in 1927, Britain's Foreign Minister Austen Chamberlain informed the House of Commons of his view that a definition of aggression would amount to, I quote, a trap to the innocent. I believe that this old concern has persisted to date, a point to which I shall return. But another part of the truth is this. When it comes to the question of independent legal scrutiny of the decision to use military force, not only the Soviet Union and now Russia, but also France, Great Britain, and the United States have adopted a position of resistance that Gary Simpson has aptly called sovereigntist. From the perspective of those states, and perhaps a few others, it was a welcome coincidence that the international human rights movement had come to see aggression primarily as an offense against the allegedly somewhat outdated value of state sovereignty as such. When scholars later conceptualized this mindset through a notion of atrocity crime that includes genocide, crimes against humanity, and war crimes, but excludes the crime of aggression, the states in question very happily came on board and used the concept of atrocity crime as a rhetorical device to sideline the crime of aggression. All this taken together explains why the activation of the ICC's jurisdiction over the crime of aggression has yet to shape the mindset of state leaders, as it should ultimately be the case. But as we are gathering here in Vienna today, there is important momentum in this very direction. Intellectually, the ground for this momentum had already been laid out quite a while before. In particular, the long prevailing divorce between the crime of aggression and human rights had increasingly come under intellectual fire in the past few years. Perhaps most clearly, Frédéric Maigret stated that, I quote, "War represents a monstrous exception to the notion that all human beings have an inalienable right to life, security, bodily and psychological integrity, freedom of movement, etc." In 2018, then, the UN Human Rights Committee recognized that, I quote, State parties engaged in acts of aggression as defined in international law, resulting in deprivation of life, violate ipso facto Article 6, that is the right to life, of the Covenant. End of quote. Hereby, the Human Rights Committee has claimed a space for the human rights conscience to address by its own distinct normative voice all the war violence inflicted by an aggressor state. Now, in the wake of Russia's full-scale war of aggression against Ukraine, we can see that this space begins to get occupied. Let me read out just a few lines of the latest report submitted by the Independent International Commission of Inquiry on Ukraine, set up by the UN Human Rights Council. I quote, "The lives of millions of Ukrainians have been appended by the loss, the disappearance, the displacement of their relatives, the destruction of cities and villages, and the lack of access to basic necessities. In addition to the human losses, the armed conflict in Ukraine has caused a population displacement not seen in Europe since the Second World War. Nearly 18 million people in Ukraine are in need of humanitarian assistance. The armed conflict has undermined access to the most basic human rights, such as the right to health, education, housing, food, and water." End of quote. This shocking summary does not even specifically mention the loss of countless lives of Ukrainian soldiers and civilians as a result of acts that do not violate the law of international armed conflict. It is thus plainly visible that the initiation of Russia's war of aggression and the continued execution of this war are nothing less than a monstrous injustice. A monstrous injustice that can be sufficiently accounted for only if the international criminal justice response includes the crime of aggression. Unsurprisingly, the Ukrainians were the first to lament the fact that the hands of prosecutor Karim Khan are currently tied specifically with respect to the crime of aggression because of the distinct jurisdictional restraints in the ICC statute. And it is telling that President Zelensky has been so emphatically joined in its call for prosecuting President Putin and other Russian leaders for crimes of aggression by the Center for Civil Liberties, led by Alexandra Matviichuk, which last year was awarded the Nobel Peace Prize. In the meantime, the call of the Ukrainians has turned into an outcry of the world's conscience, in a way that has again and again at historic junctures shaped the evolution of international law. Parliamentarian assemblies took the lead. The engagement of parliamentarians for global action is of particular note, not only because it played an initiating role, but also because these parliamentarians unite representatives from all world regions. In their plan of action of November last year, Parliamentarians for Global Actions stated that, I quote, "States must urgently and without hesitation correct the jurisdictional restrictions inserted in 2010 in Article 15 bis of the Rome Statute concerning the crime of aggression." End of quote. The culmination point of an entire series of pronouncements of parliamentary assemblies was a resolution adopted by the Council of Europe's Parliamentary Assembly. This impressive resolution, adopted in January this year by unanimity, demands that Russian and Belarusian political and military leaders concerned, I quote, should be identified and prosecuted for the crime of aggression, end of quote. The Assembly cited the UN Human Rights Committee and stated as follows, I quote again, without their decision to wage this war of aggression against Ukraine, the atrocities that flow from it, as well as the destruction, death, and damage resulting from lawful acts of war, would not have occurred. Against this background, the Assembly called on states parties to the ICC statute to, I quote, take the necessary steps to amend the ICC statute's jurisdictional regime, either by allowing referrals by the United Nations General Assembly when the Security Council is blocked, or by removing the existing limits over the crime of aggression in order to make it consistent with the other crimes subject to its jurisdiction, end of quote. Most recently, the Independent International Commission of Inquiry on Ukraine has recognized that the international criminal justice response to the war of aggression against Ukraine must include the crime of aggression. In that context, the Commission has stated that it, I quote, supports efforts to amend the Rome Statute to allow for broader jurisdiction of the crime of aggression within the statute, end of quote. All this taken together indicates a shift in world public opinion as regards the importance of ensuring accountability for crimes of aggression. And this shift was powerful enough to spill over to governments. Accordingly, in November last year, the UN General Assembly, for the first time, explicitly mentioned the activation of the ICC's jurisdiction over the crime of aggression. 1 month later, the European Council declared that the prosecution of the crime of aggression is of concern to the international community as a whole. With respect to the situation of Ukraine, a core group of presently 38 states is working towards the establishment of a special tribunal for the crime of aggression. There is a widespread feeling that this is the fastest avenue to close the jurisdictional gap within the ICC statute with respect to that situation. This conference is not about the special tribunal, and so I'm not going to deal with this question today, except for saying one thing. The fundamental principle of justice, to apply and to enforce the law equally, makes it impossible, in my view, to establish a special tribunal for the aggression against Ukraine as a short-term measure for the most pressing need, but not to confront the problem at its roots, that is, within the ICC statute itself. In other words, establishing a special tribunal as a singular event would rightly be perceived as an exercise of selective justice. This would damage the legitimacy of the operation of the global international criminal justice system in its entirety. And it would fail to send out the message that is so much needed to indeed shape the mindset of state leaders for the future. I wholeheartedly agree with United States Ambassador at Large for Global Justice, Beth van Schaak, who recognized just a few months ago that, I quote, "There are compelling reasons for why the crime of aggression must be prosecuted in the situation of Ukraine." But I wish to remind Ambassador van Schaak and all others involved that it remains true today as it was in 1945, what US Chief Prosecutor Robert Jackson emphatically declared at the foundational hour at Nuremberg, that if the law is to serve a useful purpose, it must also condemn aggression by other nations, including those which sit here now in judgment. It follows that if established, a special tribunal for the crime of aggression must be conceived as an instrument of transition, as a stepping stone towards a genuine embrace of Nuremberg's promise through a more principled jurisdictional regime in the ICC statute. After careful consideration, the Independent International Commission of Inquiry on Ukraine has arrived at the same conclusion. I quote, "A process aimed at amending the Rome Statute in parallel with the setting up of a new tribunal would demonstrate that the current conflict in Ukraine has shown the jurisdictional gap in the International Criminal Court Statute, and that the international community is now seeking to fill it based on a two-pronged approach." As it will be shown later in some detail, there are no legal hurdles to harmonize the jurisdictional regime within the ICC statute. In particular, it is far from compelling to argue, as it was done by some in the past, that the second sentence of Article 121, paragraph 5 of the ICC statute applies to the crime of aggression and makes the existing jurisdictional restraints imperative. The truth is that the ICC statute, as originally drafted, was ambiguous as to how state parties should set the conditions for the court's exercise of jurisdiction over the crime of aggression. And this means that the harmonization of the jurisdictional regime within the ICC statute is possible within a not that distant future, provided there is the political will to do so. As Benjamin Ferencz astutely noted, the latter has not been the case so far. I quote Ben, "The vital ingredient that was really lacking was the political will of a few major powers that persisted in their refusal to accept rational international controls over the use of military force." End of quote. What would it take to eventually overcome this refusal? To give the answer, we have to return to Chamberlain's well-known words of 1927. To eventually overcome this refusal would require the investment of a measure of trust in the prosecutor and the judges of the ICC. A measure of trust that these organs will apply the international consensus definition enshrined in Article 8 bis of the ICC statute in a manner that it will not result in a trap for the innocent. It was challenging to arrive at this consensus definition, and this is all the more so in a negotiation process that included states not party to the statute. First, the point of reference for the definition here, as in the case of the other crimes in the ICC statute, had to be customary international law. Yet, the state of customary international law, especially as regards the state conduct element, was a matter of some doubt. Second, there was at least a tendency, especially among the non-aligned states, to use the negotiations to progressively develop the meaning of the state conduct element of the crime so that it would align with the prohibition of the use of force in its most rigorous understanding. It must be emphasized that in the end of a laborious negotiation process, this latter tendency has not prevailed. To the contrary, the formulation of Article 8 bis is as modest as the definition of a crime under international law should be. This was key to ensure the robust consensus that eventually emerged around this definition. As I have already said, this consensus included non-state parties. Russia's Kampala delegates Gennady Kuzmin and Igor Panin stated, I quote, "Russia is satisfied with the outcome of the review conference with regard to the definition of the crime of aggression." End of quote. And China's representative Zhu Lulu wrote that in her view, the threshold clause reflects customary international law and distinguishes appropriately between illegal international acts and international crimes. Indeed, the modesty of the international consensus definition is evident from the so-called threshold clause that requires an act of aggression by a state which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. As its wording makes clear, and as the travaux préparatoires confirm, this threshold requirements implies a quantitative and a qualitative dimension. These two dimensions taken together enable the prosecutor and the judges of the ICC to interpret Article 8 bis in conformity with customary international law, as it should generally be in a case of a crime under international law. Through its quantitative dimension, the threshold requires an unlawful use of force of quite considerable intensity. Perhaps even more importantly, through its qualitative dimension, the threshold is mindful of an important fact that I have mentioned earlier. The fact that the prohibition of the use of force remains surrounded by a gray area of genuine legal uncertainty, reflective of deep-seated policy differences among states. Accordingly, anticipatory self-defense in case of an imminent armed attack, self-defense in case of a cross-border armed attack by non-state actors, or the forcible rescue of nationals abroad in dire need, do not currently fulfill the state conduct element of the crime of aggression. The same is true for so-called humanitarian intervention undertaken as a last resort to alleviate extreme humanitarian distress on a large scale if action in the Security Council is blocked. While such military action is widely considered contrary to the prohibition of the use of force, even if conducted under such stringent conditions, this position is a matter of genuine controversy. And the negotiations leading to the adoption of Article 8 bis of the ICC statute have confirmed that customary international law has not evolved up to a point where such intervention would come within the state conduct element of the crime of aggression. All this being considered, it is hard to see that the application of Article 8 bis of the ICC statute could result, I quote, in a trap for the innocent. Now, skeptics will likely ask whether the prosecutor and the judges of the ICC will in fact respect the modesty of the definition of the crime of aggression, as I've just outlined it. And of course, an honest answer must include that it is impossible to give a watertight guarantee for that beforehand. This is why accepting a more robust jurisdictional regime over the crime of aggression within the ICC statute, above all, requires the investment of a measure of trust in the prosecutor and the judges of the court. The ultimate policy question is whether it is too much to ask for such an investment in the interest of the establishment of a principled international legal architecture against aggression. In my humble view, it is not too much to ask for. And this is so for essentially two reasons. First, the risk of ill-guided judicial activism is limited indeed. Also in view of the fact that scholarly commentaries essentially concur that Article 8 bis of the ICC statute sets an appropriately high bar for prosecution. Second, the need for the establishment of a more robust international legal architecture against aggression is greater than ever. Russia's unprecedented assault on the prohibition of the use of force has challenged the international legal order at its core. We are thus, as Ambassador Beth van Schaak has rightly observed, at a critical moment in history. Therefore, it is high time for the remaining skeptics to leave their comfort zone of sovereigntist resistance and to instead allow the international legal order to be reinforced. For the remaining skeptics from the so-called global north, this also amounts to a credibility test as to how to deal with double standards in international law. If they eventually agree to a principled regime for the adjudication of the crime of aggression, they will acquire a far more legitimate position to insist on the enforcement of the law with respect to genocide, crimes against humanity, and war crimes. In the course of this year, we have seen quite some encouraging movement toward the harmonization of the jurisdictional regime within the ICC statute. In January, in her important speech at the Hague Academy of International Law, Germany's Foreign Minister Annalena Baerbock passionately called for such an harmonization. In July, she reiterated her call at UN headquarters in New York, together with Dominique Hasler, her counterpart from Liechtenstein. And the response in the room was very positive as the message we have just received by the Foreign Minister of Austria. In the meantime, a group of friends has been established to move the matter forward. Now, two things seem important. First, a concerted effort must be undertaken by European states to revitalize the interest among African, Asian, and Latin American states in the establishment of a principled international legal architecture against aggression. In view of the strong interest that states from those continents had declared in the past, as I mentioned at the outset, this should be possible. Just recall, by way of one important example, the dedication that speaks out of the following words written by Brazil's Kampala delegates Marcel Beato and Marcelo Bölke. I quote, "The Brazilian delegation strongly advocated for the need to define the crime of aggression. This position reflects Brazil's long-standing commitment to international law and specifically to the primacy of multilateral rules on the use of force. The adoption of the definition of the crime of aggression strengthens the court, fulfills an obligation undertaken by the world community in Rome in 1998, and helps ensure a more just, safe, and equitable international order." End of quote. In that connection, it is very encouraging to note that the support for this goal within civil society has been growing. If the coalition of the International Criminal Court could play a powerfully persuasive role similar to the one in 1998 in Rome, the prospects of success would be greatly enhanced. Second, in order to build on the emerging momentum, it is highly desirable to initiate before long a diplomatic process based on a concrete text proposal for an amendment. In that connection, it might serve as a helpful reminder that only the focus on actual text work during the so-called Princeton process made the momentum irresistible that led to the Kampala amendments. As we shall see in greater detail a little later, we are no longer in want of possible amendments texts. Parliamentarians for Global Action took the lead in submitting a proposal. And most recently, the Global Institute for the Prevention of Aggression, a group of about 50 international lawyers, has presented for discussion a proposal together with a detailed explanatory memorandum. We shall hear more about it before long. To conclude, there can be little doubt. Despite the encouraging movement, it will be politically challenging to achieve the harmonization of the ICC statute's jurisdictional regime. Indeed, nobody who has experienced the negotiations on the crime of aggression over the past 25 years will disagree with this prediction. But should this deter us from taking on the challenge? Over the past 25 years, each and every step forward in the direction of making the international prosecution for the crime of aggression possible involved a daunting task. At each juncture, there was powerful political resistance, accompanied by calls from self-declared realists to better abandon the project. But an overwhelming majority of states from all world regions remained determined not to abandon it because they deemed it simply too important. As a result of that determination, many seemingly unsurmountable obstacles have been overcome. A special tribute is due to states from the non-aligned movement, without whose steadfastness, neither the inclusion of the crime within the court's jurisdiction in Rome, nor the breakthroughs in Kampala and in New York would have happened. This gives very strong reason to hope that a dedicated cross-regional group of friends will successfully build on what Prosecutor Khan has aptly perceived as a new momentum as regards the crime of aggression. If the friendly work within such a group were to bear fruit, this would send a shining message at a moment of dire need. The message would be that in our multipolar world of today, dedicated cooperation across the so-called global North and the so-called global South is not only possible, but can result in strengthening the international legal order at its core. Perhaps after Rome 1998, Kampala 2010, and New York 2017, at a negotiation venue yet to be determined, the conference clock will have to be stopped at midnight for a fourth time in order to allow a principled international legal architecture against aggression to see the light of the day. But such an achievement, without the slightest doubt, would be worthy of far greater sacrifices than another such shortage of sleep. I thank you for your kind attention.